Day, my Nigerian people. Good day to everyone out there listening to me. I hope everyone is staying strong, is staying jiggy. Today's matter arises and says case transfer. Nnamdi Kanu reports Abuja Chief Judge to CJN. Nnamdi Kanu decided to go higher with his reports and case. Since he has looked around and there's nobody else to report to or no higher authority, decided to go to the Chief Judge of Nigeria. Because who better will be able to do this and send his case to a different judge, if not the CGN, since the Chief Judge, Justice Toho, has decided that he will not listen to why he should not give Justice Benta Nnamdi Kanu's case. This is what he can do. This is the best he decided to do for himself. Now let's get into the content of the day to know what exactly this content entails. The detained leader of the indigenous people of Biafra, Nnamdi Kanu, has petitioned the Chief Justice of Nigeria, Justice Kudirat Kekere Ekun, urging her to direct the Chief Judge of the Federal High Court, Justice John Toho, to reassign his case to another judge with proper jurisdiction. In a letter dated February 20th, 2025, obtained by our correspondent on Wednesday, Kanu's legal team, led by Aloy Ejimako, argued that Justice Binta Nyako, who is currently presiding over the case, had already recused herself following Kanu's allegations of bias. Kanu is facing 7 counts of terrorism related charges brought against him by the federal government. During a court session on September 24, 2024, Kanu formally requested Justice Nyako to step down from his trial, citing a loss of confidence in her handling of the case. In response, Justice Nyako announced her withdrawal and returned the case file to the Chief Judge for reassignment. However, Justice Toho later returned the case file to Justice Nyako, instructing her to continue presiding over the trial. At the next hearing on February 10, 2025, Kanu again rejected Justice Nyako's authority, arguing that since she had recused herself, she was disqualified from further handling the case. He insisted that he appeared in court only out of respect for the rule of law. Following the standoff, Justice Nyako adjourned the trial indefinitely, signed I. In his letter to the CJN, Ejimako argued that legal principles dictate that once a judge recuses themselves, they are disqualified from further involvement in the case. He urged the CJN's administrative intervention to ensure that the case is reassigned. Once a judge voluntarily recuses themselves, the immediate legal consequence is that they are disqualified from further proceedings. A decision or order of recusal is akin to a ruling on jurisdiction and cannot be reversed arbitrarily, Ejimako stated. Ejimako also stressed that public perception and judicial integrity are at stake, warning that assigning a case to a judge who had recused themselves could erode confidence in the judiciary. Public trust in the court is crucial. If a judge unilaterally resumes a case after a recusal, it creates a perception of partiality and undermines confidence in the judicial process, he stated. Ejimako further revealed that Kanu had launched a formal complaint against Justice Nyako with the National Judicial Council on January 14, 2025, and that the petition was still pending. In conclusion, Kanu's legal team urged the CJN to use her authority to ensure a fair trial, either by transferring the case to another judge in Abuja or to a court in the southeast. Hmm. He decided to go to a higher authority. Someone that hopefully will listen to them and see reasons to why Justice Binta Nyako cannot preside over the case after her recusal, with everyone saying the same thing, that the law lawfully is not supposed to be. She's not supposed to preside over the case. Even if Justice Toho actually asked her to, she's not supposed to, since she already preside over the case. So that's whole answer, or that whole excuse of her saying, oh, the chief judge asked her to preside over the case, is not supposed to be. In fact, at this point, we don't even know which one is the law actually, because all the barristers and lawyers and judges all read one constitution, one book, in different universities. It's supposed to be one book. But for some reason, all of them are having a different ideas. They're having different ideas on this case. Some people are saying, and she's not supposed to be, but since the chief judge asked her, she's supposed to preside over the case. Some people are saying that whether chief judge or no chief judge, for the fact that she requests herself, she's not supposed to preside over the case. At this point, let's say me, I'll go read constitution because I don't understand what it happen. We don't even know who is telling the truth or not. It's not looking like they read different books for different schools, for different lawyers. Is that how it's supposed to be? It's not. So they say to go to the CJN, and we all wondering what the CJN response would be. That's if she give a response. If she decides to give a response, will she agree to sending the case to a different judge like she's supposed to, or will she leave it there with Justice Binta Nyako? Because if that happens, then everyone in this country, no, some people are still like, okay, we're not really sure if this whole Nnamdi Kanu's case is actually politically done. But if at all she refuses to send this case to a different judge, if not just because of the fact that Justice Nyako is not supposed to preside over the case or anything, but just for the reason that Nnamdi Kanu's case is taking too much time, she's supposed to send it to a different judge. It's taking too much time, it's not moving forward, nobody is knowing exactly what it's supposed to be. That is enough reason to take it to a different judge. But we wonder what her answer will be and what her response will be. And we are waiting. But for now, we've come to the end of today's content. Do not forget to subscribe and stay tuned to our channel. Thank you.